Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Once again, SHREYA Singhal case has come into searchlight. Day before yesterday, that is on Monday. You know the date, I need not reiterate. The Honorable Supreme Court of India, Chief Justice Shri U. Lalit, Justice Ravindra Bhatt and Ajay Rastogi, 3 judges bench, while disposing the case of People's Union for Civil Liberties versus Union of India in WP criminal number 199 by 2013 in MA 901 by 2021, held that the books should show that SHREYA Singhal case has been held unconstitutional. The section 66A is held unconstitutional as per SHREYA Singhal judgment, and they have given clear directions to the states, particularly to the Director Generals of Police and Home Secretaries also. Why all these things is happening? Better to know. Let us go to the grassroots, that is 2015 judgment. SHREYA Singhal versus Union of India. It is, you can see the 2015 judgment in volume number 5, SCC, page number 1. What is this case? This is relating to section 66A of the Information Technology Act. This act came into force in 2000. 66A says whoever publishes any grossly offensive or menacing message through computer or computer resource like mobile phones, they are liable under section 66A, and the offense is punishable up to 3 years imprisonment. And in 2012, you all know that the Shiv Sena leader, very famous leader, Bal Thackeray, he died. So the entire Bombay city, entire Maharashtra, Bombay city, they have observed 2 days mourning, Santapadinal mourning. So 2 students, particularly girl students by name Shaheen Dada and Renu Srinivasan. Actually, Shaheen Dada, she made a Facebook, she has written her statement or opinion in the Facebook, stating that why so much of disturbance to the public? Why 2 days mourning? If the cadre has got so much of respect for him, let them go to his cemetery or his samadhi, and why don't they pray for him? Why should they disturb the life of the common people? Because I think they have to pay some 10th class fee or something like that. And Renu Srinivasan, she has ticked the same. That means she has liked or forwarded the same. I don't know the technology relating to the latest social media platforms. And this has irked the feelings, created the ill feelings among the Shiv Sena people. So in order to suppress the emotions immediately, the police resorted to the arrest of the girls. Of course, they were immediately released. But a law student, young, active, public-spirited law student by name SHREYA Singhal, she brought this to the notice of the Honorable Supreme Court of India, and this case is famous as SHREYA Singhal versus Union of India 2015. And the important topic of freedom of speech with its restrictions, it has been discussed at length by the Honorable Justices Rohinton Nariman and also Justice Shalmeshwar in this particular case, and held that the section is not worded properly. Please remember, the section is not worded properly. Section 67C of the Act as well as IPC penal provisions are sufficient. 66A is held to be unconstitutional. Finish. But still, police are using this, and police are prosecuting some people because the section has not been repealed. You know what happened to section 303 in Mithu versus State of Punjab? Yes, the section has been repealed, but here it is only held unconstitutional. That means the section is there, 66A is there, But at present, since it is held unconstitutional, you cannot file any case. But still, number of cases have been being filed against the people. In 2018 or so, once again, the Supreme Court cautioned and they have given notice to the central government. But central government conveniently stated that it is the prerogative of the state's police. But still, central government of the police is also to some extent a state subject. IT Act, it is a special act, it is a national subject, center subject ultimately. Now, therefore, once again, the case has come up. PUCL, so People's Union for Liberty, Advocate Johab Hussain or somebody, okay, they have brought it to the notice of the Honorable Supreme Court of India by filing the writ petition in 2013 itself. Anyway, so after taking so many steps and after crossing so many hurdles, yesterday the judgment has come. So please remember, still, it is observed that citizens are facing prosecution under Section 66A of the Information Technology Act. Such proceedings are definitely infringing the rights of freedom of speech and expression. Social media platform, nowadays everybody is taking advantage of the social media platform and they are actually filling it with their opinions. Yes, we have to accept them. Suppose if they are menacing, then you can take action. So nowadays, AP government, lot many cases are being booked, but most of them are being booked under Section 153A, 124A sedition, or so-called 153A and 120B of the IPC, but not under IT Act. You have to know this also, in particularly those who are staying in Andhra Pradesh. Now, the Supreme Court yesterday, they have given clear-cut directions. So the directions are: number one, no citizen should be prosecuted under 66A year afterwards. There is no prosecution. You cannot file any charge sheet against a person on 66A of the IT Act. Number two, the Section 66A shall be deleted. So against in the charge sheet, suppose if the police have filed any case under Section 500, 66A like that, 66A should be deleted. But this deletion will not apply to the other sections. Suppose if the case is under Section 500 IPC as well as 66A, only 66A will be deleted. This is the second direction. Third, the Director General of Police and also to the Home Secretaries, they have to give once again the instructions to all the officers in the state not to add Section 66A of the Information Technology Act. And fourth instruction is, suppose if any Bear Act is being published, we are going to purchase them also. In any IT Act book or Bear Act book which is going to be published, they should clearly inform under Section 66A that SHREYA Singhal case has held it as unconstitutional. So this is a precedent. So please remember, the Bear Act has to inform the readers that 66A is violative of the Constitution, that is Article 19, freedom of speech and expression. So in this connection, Supreme Court has relied on a very famous case, Ramesh Thapar versus State of Madras, 1950. Sakal Papers Limited, Private Limited and others versus Union of India, I think 1962. Placing reliance on the age-old landmark judgments. Yesterday, Supreme Court disposed of the petition with the directions to the center as well as the state also. So once again, Supreme Court the discussion on SHREYA Singhal case has come up. So particularly the students who are pursuing 5 years, second year people, definitely you must be aware of the called SHREYA Singhal judgment, because I will tell you at the time of the IT Act cases, but anyway, be prepared from now itself that Section 66A is violative of the Constitution of India. Okay, with this I am concluding. Thank you very much.